Our first item for today is item number 1, AB 775. Mr. Chiu, when you're ready. And for this item, we're going to conduct the hearing in a little different way. We will be allowing 15 minutes for each side to present, and following each side, then I will ask folks who are wanting to weigh in on the bill to come to the microphone, say your name, your affiliation, and that you support or oppose the bill. But we will not be taking further testimony after the 15 minutes. And you don't have to take the 15 minutes, but I will allow up to 15 minutes for a presentation on both the proponents and opponents of the bill. So, Mr. Chiu. Beyond.
Thank you, Mr. Chair and colleagues, and I appreciate your consideration of AB 775, the Reproductive Fact Act, and I also want to thank the committee consultants for their thorough analysis of our bill. Our state and our California legislature has had a long legacy of protecting a woman's constitutional right to choose, established by the Supreme Court in Roe v. Wade. This bill continues that legacy by ensuring that women can make reproductive choices based on information that is scientifically accurate and timely. Unfortunately, we have seen a rapidly growing number of organizations who've tried to pass themselves off as women's medical clinics while providing false information and risking delays to critical early care. In California, for example, we've seen over 160 of these so-called crisis pregnancy centers. Our state has a compelling state interest to make sure that all pregnant women have timely access to health care when it comes to pregnancy-related services, whether prenatal care or an abortion. These organizations often delay that care, which can lead to complications, serious health outcomes, low birth weight babies, and other negative outcomes. This bill helps to address our state's compelling interests. Since there's been a lot of misinformation about the bill, let me just be clear for a moment about what AB 775 does not do. Our bill does not require referrals to abortion clinics. It doesn't provide a preference to one kind of clinic over another. It doesn't prevent any centers from providing current ongoing services, and it doesn't discriminate on the basis of viewpoint or religion. What does our bill do? Our bill requires licensed facilities to provide a simple notice that free or low-cost public programs are available for comprehensive family planning services, prenatal care, and abortion services. And our bill also requires unlicensed families to provide a simple notice that its facilities are unlicensed and that there are no licensed medical providers on staff. This bill has been drafted based on other laws upheld by the courts, and I want to take a moment and thank the Attorney General's office, who's represented here today, for working with our office to ensure that the language is consistent with constitutional law and that AB 775 will withstand judicial scrutiny. I want to thank the diverse group of health providers, women's organizations, religious groups, community leaders, as well as our co-authors, Speaker Tony Atkins, members Rendon and Dr. Wood. I also want to take a moment and thank our co-sponsors, NARAL and Black Women for Wellness. And at this time, I'd like to turn it over to our joint author, Assemblywoman Burke.
Ms. Burke.
Thank you, Mr. Chair. Thank you, Mr. Chair and members. California has been a leader on reproductive rights, and for decades we've worked to protect those rights and preserve access to safe, affordable health care for all women. We've long guaranteed a woman's right to privacy to make her own reproductive choices and have access to basic level of health care. But that right is an empty promise if she lacks the ability to obtain care or services or if she doesn't know about all the options available. Women in California deserve to know about all of their options for family planning and reproductive health care so that they can make truly informed decisions. AB 775 simply ensures that we are getting the accurate and complete information that they need wherever they turn for care. The opposition will claim that this is discrimination and that they are being unfairly singled out. I disagree. With this bill and existing California law, all clinics will be held to the same standard and all patients will have access to clear, timely information about their health care rights. I respectfully request your aye vote.
Thank you. And we're going to pause here for a moment and establish a quorum.
Stone.
Here.
Wagner.
Here.
Alejo. Chow.
Here.
Chiu. Gallagher. Garcia.
Here.
Holden. Mainshine. O'Donnell.
Here.
Thank you. We do have a quorum. Please proceed.
We have a number of witnesses today. I'd like to turn it over to Amy Everett from NARAL.
Thank you very much and good morning. My name is Amy Everett. I'm the State Director at NARAL Pro-Choice California. We organize our over 70,000 members in California on behalf of protecting and expanding reproductive freedom. Deciding if or when to have children is a very time-sensitive decision, and women in California need all the information to make the best decisions for themselves and to get prompt access to health care. That's what the Reproductive Fact Act will do. AB 775 makes sure that if women seek care at a facility that does not enroll patients in FPAC or Medi-Cal, they will walk out of that facility with information in hand and a phone number to call so that they can get contraception, prenatal care, or abortion in a timely manner. AB 775 ensures that a woman knows how to access assistance right away for all of her reproductive health options and get medical care without delay. We know California could be doing more. For example, the most recent public data from the San Francisco Department of Public Health shows that women who are on Medi-Cal are 6 times as likely to miss first trimester prenatal care as women on private insurance. If eligible women do not enroll in Medi-Cal early enough in a pregnancy, they may not complete the process in time to have the delivery costs covered. Women need to know about access to care at the time they are seeking services. If they do not receive this information, it can delay their access to care. Women who wait for prenatal care have a higher risk for a preterm or low birth weight baby, which can lead to increased risk of health problems in the long term. Waiting to obtain abortion care means that procedures become more expensive and difficult to obtain, and especially in areas where abortion providers are few and far between. The state has an interest in helping women prevent unintended pregnancies, which means that women need immediate access to affordable contraception and family planning services. This bill does not require statements that imply preference for any reproductive health option. It simply ensures that women receive important information that will empower them to make the best reproductive health care decisions for themselves and their families and receive affordable care. We can all agree women should have complete and accurate information when making critical health care decisions. The Reproductive Fact Act helps make sure that all women get access and information in a timely manner, and NARA Pro-Choice California respectfully ask for your aye vote.
Good morning, Chair and members. I'll be brief. Thank you for the opportunity to testify. My name is Robert Sumner, and I'm Deputy Attorney General working under Attorney General Kamala Harris. I'd first like to apologize that we weren't able to formalize our support on this bill in time for the committee hearing. But I can certainly say that AG Harris supports the intent of this bill, which is certainly a very compelling state interest. Really, at its core, what this bill is about ensuring timely access to health care services, and as part of the AG's mandate, we need to ensure that California continues its legacy for providing protections for Californians that seek urgent care. The intent of AB 775 really goes beyond crisis pregnancy centers and goes into the basic mandate that we have as public servants to ensure that there is never any inhibition to receiving adequate care under the law. AB 775 has been tailored, I think, in recognition of the balance that courts have struck when regulating this type of activity. As it relates to the licensed facilities, we've seen in multiple cases, as recently as Pickup v. Brown and them citing Planned Parenthood v. Casey, one of the landmark cases, that when we're dealing with professional speech in a medical setting like this, there is a First Amendment recognition of the need for the state to have the authority to provide some guidance and regulation for how those medical service information is conveyed. Nothing about this bill does anything to regulate conduct by a medical professional. It has no bearing on whether or not referrals are made or whether or not recommendations are made. It doesn't say anything about the preferability of any particular option. It merely makes sure that every patient or every client is aware that those options are available. While it's content-based, the viewpoint neutrality and the very compelling state interest, which I believe Ms. Everett made very clear, makes this bill something that we should all be proud to support, and I'd like to thank you all for considering it today.
Thank you. That completes your presentation? Great. Then I'm going to ask for the next witnesses who are in support of the bill to give your name, your affiliation, and that you support the bill.
Okay.
Please.
Shannon Smith-Crowley, representing the American Congress of Obstetricians and Gynecologists for California, in strong support and urge your aye vote.
Rebecca Griffin, as an individual, I strongly support this bill. Christina Romero, Planned Parenthood Affiliates of California, and strong support.
Sylvia Solis Shaw on behalf of City of Los Angeles Mayor Eric Garcetti in strong support.
Chelsea Gelbart here representing Black Women for Wellness in strong support.
Eileen Schnitker, Women's Health Specialist of California, strong support of the bill, urging your aye vote.
Zori Whitaker, an individual in complete support of this bill. Thank you.
Sasha Zazie Western, in support of this bill.
Julie Linden, volunteer with Women's Health Specialists, in strong support of this bill.
Elaine Sierra, on behalf of Nevada County Citizens for Choice, in strong support of the bill.
Dennis Garcia with the California Latinas for Reproductive Justice, in strong support.
Carol Moon Goldberg with the League of Women Voters of California, in support. Thank you.
Anyone else in support?
Diana McDonald, Women's Health Specialist, in strong support.
Shireen Dada, Legal Monitor of Women's Health Specialists, in strong support of this bill.
Lindsay Arnaz, Women's Health Specialist, in strong support.
Thank you. Anyone else in support? All right, seeing none, we'll move to the opposition. Please come forward to the table. They'll make room. Thank you. And gentlemen, you have up to 15 minutes for an organized presentation.
Chairman Stone, members of the committee, thank you for the opportunity to speak. My name is Sheldon Hadley. I'm an attorney in private practice and board chairman of 2 licensed medical pregnancy clinics. Under the Hyde-Weldon Amendment, first enacted in 2005, federal law prohibits a state from discriminating against a healthcare provider because the healthcare provider refuses to provide or refer for abortions. A state that discriminates against a healthcare provider because the healthcare provider refuses to refer for abortion risks the loss of federal funding for healthcare-related programs. This federal law, also known as a federal conscience protection statute, is contained in a federal appropriations bill and as such has been renewed every year for the past 10 years, including those years when both the House and the Senate were controlled by the Democrats, and has been signed into law by President Obama every year he has been in office. The right of an American to refuse to be involved in an abortion, including the right to be free from the obligation to refer either directly or indirectly for an abortion, is a right with bipartisan support. This right of freedom of conscience has been upheld by the U.S. Supreme Court in numerous cases. AB 775 is about abortion and referrals for abortion. This bill forces all California pregnancy centers to refer for abortion. The bill targets pregnancy centers and pregnancy centers alone. The bill states specifically that the state government must, quote, supplement its own efforts to advise women on how and where to get abortions. The state is ordering the pregnancy centers to supplement the advice the state is currently giving pregnant women. The bill requires a certain notice to be given every client. The notice states in part, quote, California has public programs that provide immediate low and free access to ... abortion. To determine whether to qualify, contact the county social services at, close quote, and then we're supposed to put in a phone number. Clearly, a central purpose of the notice is to advise the client that the state may provide a free or low-cost abortion, and if the client is interested, the client is referred to County Social Services Office with a phone number to begin the process. That is a referral for abortion. The authors of AB 77 know the Hyde-Weldon Amendment prohibits abortion referrals and discrimination or forced abortion referrals, and therefore were careful to avoid using the word referral in the bill. But a rose is still a rose by any other name. Because the Hyde-Weldon Amendment itself does not define refer under the law, the words ordinary and usual meaning is applied. A review of half a dozen well-known standard dictionaries for the word refer shows the following definitions. Quote, mention, quote, allude to, quote, direct the attention of someone to, quote, to turn or direct to a source for information or help, quote, to send or direct for treatment, aid, information, or decision. Under any one of these definitions, AB 775 requires pregnancy centers to refer clients for abortions. AB 775 directs clients to a source for help and information on how and where to get free and low-cost abortions. The word abortion is used 4 times in the bill. In addition to direct reference to abortion services, the bill also refers to family planning services and reproductive decisions, all of which are referrals to services which include the option of abortion. The bill is about abortion. The stated purpose of the bill is to supplement the state's efforts to help women obtain abortions. To force health care providers to make referrals for abortion is illegal under federal law, risking the state's loss of much-needed federal funds for health care, and violates health care providers' right of freedom of conscience. Those were my prepared remarks. I didn't realize I would have so much time, at least in comparison to 3 minutes. So let me give you now some of my offhand remarks. I've been doing work for pregnancy centers for 30 years. All of it's been voluntary. I have seen thousands and thousands of people in our communities that I work in, both the Yuba Sutter area as well as Butte County and Chico. I've been board chairman of the one in Yuba Sutter County for 30 years and the one up in Chico for 20. I don't get paid a penny. I do it all voluntary, and the reason I do it is because I have seen the great results. I have seen so many people helped. This report is a biased report. It's like going into the Ford dealer to find out about Chevys. You're probably not going to get a real good picture. It's not fair. In a court of law, that report would be thrown out. It's hearsay. And to take these centers who have so many thousands of people, so many millions of dollars committed into the communities. I mean thousands and thousands. Our center, just in Yuba Sutter, which is not a real healthy economic base, we see a budget of $400,000. You know where that money comes from? People giving it. Not big corporations, but mom and pops in the community. Thousands of them. And people committing thousands and thousands of hours. And to take that because NARAL, National Abortion Rights, says that we're not doing a good job is phony. And again, it's just like going to the Chevy dealer. They could pour out all the recalls Ford has had, all the problems Ford has had. Well, yeah, we're not perfect. Is anybody in this room perfect? I run a law office for 30 years. I've made mistakes. I've had my secretary from time to time say something that she probably shouldn't say. I probably said things that I shouldn't have said. I've got my law clerk. He sometimes says things that he shouldn't say. Does that make it I should be subject to regulation for everything I say? Most of these centers have medical directors. They are doctors that oversee, and their licenses are on the line. And for the judiciary to step in or the legislator to step in and say, this is the way we want you to do your job, that isn't right. Most of our clients come from referrals. We keep stats on where our clients are coming from, and I look at them every single month, and I have for 30 years. And I can tell you, I can testify, I can swear under oath that the vast majority of the clients and the centers I deal with come from referrals. We don't have large advertising budgets. We're running off of donations. So people are coming back because they like us, because we do a good job. And to impose this upon us and to violate our conscience. I got a conscience, and this violates my conscience. And that isn't right.
I'm going to ask the audience not to please interrupt the speakers.
And it is a big deal. I'm doing this not because I'm being paid. I'm giving thousands of hours to this, not because I'm being paid, but because of my own conscience, because of my own heart, because of my own dedication. And for the government to come in and say, Hadley, this is the way you'll do it, violates my conscience. I shouldn't be required to refer for abortion. I do not think abortion is a good thing. And I could sit here and debate that with anybody all day long, and a lot of good data on it. But of course, that's another day and another time. But the point is that I have the right. That's what so much of America is about. That minorities, if I'm a minority, my rights are protected too. We don't just protect the rights of the majority. And whether I have a view that might be a little bit different than yours, I still have the right for my mind to be protected, my heart to be protected, my conscience to be protected. That's what makes America great, that we just don't say the majority gets their way and we roll over those that disagree. And we do provide timely access. In fact, many of these ladies that come in, they haven't even gotten Medi-Cal yet. We do so much referral for Medi-Cal. Oh my gosh. We do all kinds of referral for Medi-Cal. We've got a whole book that's nothing but our referral book. It's got all kinds of referral information in it. So the idea that we're taking away from women getting timely health care is just the opposite. We, in fact, are often the first place they go, and we get them medical care right away to the extent we don't have it.
Point of order, Mr. Chairman. Is it 15 minutes per speaker or 15 minutes per side?
Per side.
Because I'm wondering whether Mr. Snyder might have anything to add to this before the time expires.
Thank you. I appreciate that. Thank you.
Mr. Chairman, members of the committee, good morning. My name is Kevin Snyder. I'm with Pacific Justice Institute, where I serve as chief counsel. If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. The U.S. Supreme Court penned those words 70 years ago. They're still true today. This committee has an obligation as a Judiciary Committee to protect that principle. You have an obligation through your oath of office, to stand for the First Amendment, for speech and for conscience. When the government requires a party to advertise its message, such is compelled speech. But not all compelled speech is unconstitutional. There can be compelling interests. There can be, as long as they're narrowly tailored or show the least restrictive means. But the cases involving compelled speech, the constitutional question hinges upon context. A court recently had occasion to review an ordinance with striking similarities to AB 775 passed by New York lawmakers. Like the present bill, clinics were required to provide to women a bare-bones government message. On this key question of context, the court found that it is part of, quotes, a public debate over the morality and efficacy of contraception and abortion, for which many of the facilities regulated by the law provide alternatives, end quotes. That's the context. We all agree with that. That is precisely the context in which AB 775 rests. In striking down the main portions of the law, the court noted that expression on public issues has always rested on the highest rung of the hierarchy of First Amendment values. AB 775 requires crisis pregnancy clinics to affirmatively advertise for the government. The notice in the bill, as presently drafted, provides no clarification that the government is the speaker rather than the clinic. As written, the notice advising women relative to contraception and abortion leads to the false perception that the speech comes from the clinic itself. Please read the notice. Read the notice. Ironically, the bill's analysis claims that the object is to prevent, quote, deceptive practices. Make no mistake, it is the notice that is a deceptive practice. Mr. Chairman, in view of the time constraints, I ask that my written remarks be included in the record, and I urge this body vote nay on this bill. Thank you for your deliberation and your service to the community.
Thank you. Does that conclude your presentation?
I believe we're out of time. I don't know. I understand we're out of time. Yes.
Okay. Thank you.
Thank you.
I'm now going to open it up to members of the audience who would like to come up and address this committee. Again, please give your name, your affiliation, and that you oppose the bill. This is those who are opposed to the bill. Please.
Thank you, Mr. Chairman. Brian Johnston with the National Right to Life Committee and the California Pro-Life Council. We urge a no vote on this bill. Thank you.
Carol Dodds, Executive Director of A Woman's Friend Pregnancy Medical Clinic in Yuba City and Marysville. I, along with our 5,000 supporters, urge you to vote no on the bill.
I'm Angela Bennett with the SCV Pregnancy Center, representing 3,000 supporters who urge you to vote no on AB 775.
Good morning, Assembly members. Jeanette Kaipoff, representing over 5,100 supporters with Women's Pregnancy Care Clinic of Whittier and Pasadena communities, urging you to vote no.
Carissa Metcalf, strongly urging you to vote no on AB 775.
Kelsey Gergens, please vote no on AB 775.
Ilona Anderson, please vote no on AB 775.
Joy Johnson, 33 years as an RN here in California. I urge you to vote no on AB 775.
Denise Nix, professional clinical counselor. I urge you to vote no on this bill.
Kathy Seepy, CEO of Living Well Medical Clinic, and I and our 3,700 supporters oppose this bill.
Marie Leatherby with the Sacramento Life Center, representing our 10,000 supporters. We urge you to vote no on this bill.
Elizabeth White, Living Well Medical Clinic. I urge you to vote no.
Mary Sari, retired nurse. Please vote no.
Lynn Fuller, Executive Assistant, Sacramento Life Center. Please vote no.
Maxine with A Woman's Friend Pregnancy Center Clinic in Marysville. I urge you to vote no. Thanks.
Kristen Bird, Post-Abortive Woman. I urge you to vote no on 775.
Michelle Gonzalez, Registered Diagnostic Sonographer. I urge you to vote no.
Good morning. Brenda Dowden, Chico, California, Executive Director, Women's Resource Clinic. 10,000 supporters. Please vote no.
Jamie Prince, I strongly urge you to vote no on AB 775.
Blaine Wittig, Options for Women, representing 3,000 supporters. I urge you to vote no.
Melissa Dean, I urge you to vote no.
Cindy Brosi Van Grunau, J. Raffe Medical, Eureka, California. I oppose this bill.
Cindy Gates, a post-abortive woman. I urge you to vote no on this bill.
Marcia Cecil, former Executive Director for A Woman's Friend Crisis Pregnancy Center. I urge you to vote no.
Frank Cecil, volunteer and supporter of the women's right to choose. I ask that you vote no on this.
Barbara Mejia, A Woman's Friend Pregnancy Resource Clinic in Marysville, also post-abortive. I urge you to vote no.
Damaris Burrell, Vice President of the Board of A Woman's Friend Pregnancy Resource Center, post-abortive woman, and I strongly urge you to vote no on this bill.
Cindy Alon, Director of Development, Women's Resource Clinic, Chico, and I urge you to vote no.
Hi, good morning. My name is Leslie Lewis, and I'm asking you to vote no.
Judy King here for Catholic Advocacy Days. I urge you to vote no on this bill. Thank you.
Leilani Freitas. I'm opposed to Board of Women, Chico, Respect for Life Committee. I urge you to vote no, please.
Mary Waldorf, representative of Chico Respects Life, 1,000 supporters. I urge you to vote no.
Leslie Foss, 40 Days for Life Sidewalk Counselors and Post to Board of Women. I urge you to vote no.
Winnette Sills, Californians for Life, with members in each of your districts. We strongly urge a no vote on this bill.
I'm Hannah Costin, a San Francisco resident, and I strongly urge you to vote no on this bill.
My name is Isaac Costin. I'm also a San Francisco resident, and I urge you to vote no on this bill.
Renelle Caleb, registered nurse, also a San Francisco resident. I urge you to vote no.
My name is Chastity Ronan. I am also a San Francisco resident. I am the executive director of Alpha Pregnancy Center, representing over 5,000 supporters and over 7,000 women who have received our support. We urge you, please vote no.
My name is Diane Stone. I'm a registered nurse and nurse manager for Tracy Pregnancy Resource Center, and I strongly urge you to vote no for this bill.
I am Ruth Van Hall, a registered nurse, and I urge you to vote no on AB 775.
I am Dr. Bernard Van Hall, a medical physician at Women's Friend, Marysville, California. I urge you to vote no.
Hi, I'm Judy Morozinski, registered nurse, volunteer at a Woman's Friend in Marysville. Please vote no.
Hi, I'm Andrew David Hansen. I was born with severe birth defects, and I urge you to vote no on this bill.
My name's Carol Duty. I'm the director of Pregnancy Support Group of Woodland. I represent over 2,000 supporters. I urge you to vote no on 775. Thanks.
I'm Bethany Layton, a volunteer client advocate at Alternatives Pregnancy Center, and I urge you to vote no.
I'm Julia Brosterhouse. I'm a registered nurse and nurse manager at Alternatives Pregnancy Center, and I urge you strongly to vote no.
I'm Ashley Donald, the receptionist at Alternatives Pregnancy Center, and I urge you to vote no.
Hi, I'm Brooke Odgers. I'm the office manager for New Life Pregnancy Center in Placer County, and I'm also the product of an unplanned teen pregnancy, and I urge you to vote no.
Good morning. I'm Lori Jennings, pastor of Faith Legacy Church in Sacramento, and I urge you to vote no.
My name is Tanya Flores, and I provide after-abortion care for Alternatives Pregnancy Center in Sacramento. I strongly urge you to vote no.
Good morning. My name is Kimberly Castro, and I'm a very concerned citizen of California, and I urge you to please vote no on AB 775. Thank you.
Good morning. I'm Jeanette Burrell, and I'm a client advocate with the Alternatives Pregnancy Center in Sacramento, and I urge you strongly to vote no on this measure. Thank you.
I am Adam Heltzley, and I strongly urge you to vote no on AB 775.
Good morning. I'm Debbie Jones, and I'm with the Compassion Pregnancy Center Medical Clinic in Monterey, California. I represent 2,500 supporters, and I urge you to vote no.
David Jones, individual, urge you to vote no.
April DiCarlo, RN, urging you to vote no.
Tricia Lewis, Executive Director, New Life Pregnancy Center in Placer County. I urge you to vote no.
Good morning. I'm Janet Niemeyer, the Executive Director of Caring for Women in Oroville, California, and I'm representing over 3,000 supporters, and I appeal to you to please vote no.
Dean Tarsi, and I'm a supporter of all these pregnancy centers that do some loving and compassionate work, and also with Alternative Pregnancy Center as a volunteer. I urge you to vote no. Thank you.
My name is Shannon Hughes, and I urge you to vote no.
Good morning. My name is Ann Axtell, RN, and I
strongly urge you to vote no on this bill.
My name is Chuck Hughes, and I strongly urge you to vote no.
Dick Jones, environmental scientist, and I urge you to vote no. Thank you.
I'm Ellen Giannoli. I've been a RN in California for 42 years. I'm a nursing instructor. I was formerly on the public health nursing staff for the state of California. I'm from Shasta and Lassen County. I'm here for Catholic Advocacy Day, and I strongly oppose AB 775. Please vote no.
My name is Kathy Peterson. I'm with New Life Pregnancy Resource Center, and I strongly urge you to vote no.
Good morning. I'm Linda Powell, and please vote no on this bill.
Good morning. I'm Sue DeBruin. I too am post a board of 2 times, and I work with New Life. And from myself and my husband, who Dr. Mark DeBruin, would wish you would deny this bill. Thank you.
Samantha Torres-Wright, ask you to oppose Bill AB 775.
Good morning. I'm Linda Clift with the Pregnancy Resource Center of Tracy, and I urge a no vote.
Hope Vega, I urge you to vote no.
Skip Vega from Holy Family Church in Artesia, and I please ask you to vote no.
Good morning. My name is Cindy England, and I'm on board with the Compassion Pregnancy Center in Monterey Bay, and I strongly urge you to vote no on AB 775.
Good morning. James Smith. I urge you to vote no on AB 775. Thank you.
My name is Laura Fagundes, and I strongly urge you to vote no on 775.
Hi, I'm Judy Hewitt from Pregnancy Counseling Services in Placerville, California, and I urge you to vote no.
My name is Sherry Monath-Smith. I'm a labor and delivery registered nurse and a certified childbirth educator, and I urge you to vote no on this bill.
Good morning. My name is Nancy Hansen, and I'm the Executive Director of the Center for Life Choices in Ukiah, representing over 1,100 donors and thousands of women who we have helped. I urge you to vote no on this bill.
Hello, I'm Winona Hayes, a volunteer at the Center for Life Choices in Ukiah. I strongly oppose this bill, and I urge your vote, please, against it. Thank you.
I'm Holly Verhalen, and I've nursed for 30 years, and I urge you to vote no on this bill.
Carrie Peterson, Yuba City, please vote no.
Annabelle Ward, please vote no.
Hello, Lisa Schippelhoot, please vote no.
Judy Lemke from West Sacramento, and I beg you to please vote no on this bill. Thank you.
Ernie Lemke, World War II vet, I urge to vote no.
Ann Foster, individual registered voter in Rancho Cordova, I urge a no vote.
My name is Suzanne Motola. I'm a former director in Hawaii, but I have been residing in Chico, California for 6 years. I urge you to vote no on this bill.
Good morning. My name is Carolyn Dehart, Post a Board of Women. I urge you to vote no, please, on AB 775.
Good morning. Bob Guild, Executive Director of Alternatives Pregnancy Center in Sacramento. On behalf of our supporters, I urge you to vote no.
Jonathan Keller with California Family Council and California Family Alliance. I just wanted to thank Chairman Stone and Mr. Chiu. I do appreciate your heart for women. However, as someone who did my Eagle Scout project for Alternatives Pregnancy Center 15 years ago,
tell us whether you support.
Please vote no
or oppose the bill. Thank you.
Thank you.
Good morning. My name is Patricia Del Marmo. I am the Northern California Area Director for Concerned Women for America, which is the largest women's organization in the nation. We have about 20,000 members for California, and I urge you to vote no. Thank you. And I have proof of the good stuff.
I'm Reverend Olga Herman, and with JC Research Center here in Sacramento, and I oppose AB 775. Thank you.
Murray Lewis, 35 years pro-life ministries, activist, and in opposition to this bill. Please vote no.
My name is Charles Yarbrough. I'm the president of Arcade, Roseville Creation Science Clubs, and I urge everyone to vote no. And I oppose this bill.
I'm Kate Murphy from Sacramento, and I strongly urge you to oppose this bill.
Sandra Palacios with the California Catholic Conference, also in strong opposition to this bill.
I'm Kathleen DeSantis, a private citizen, a Rachel's Vineyard supporter, and also opposed to Board of Women, and I ask you to vote no.
I'm Mike DeSantis, opposed to Board of Father. I urge you to vote no, as do your dead taxpayers.
Paula Leary, Executive Director, Pregnancy Medical Clinic in Lodi, and I strongly oppose this bill.
Kathleen Moran, Board Member, Pregnancy Medical Clinic of Lodi, and I strongly urge you to oppose this bill. Thank you.
I'm Joanne Westgate from Lodi, representing the PRC of Lodi, and I strongly oppose this bill.
I'm Ralph Merletti, from member of St. Rose Parish, South Sacramento, and I strongly urge a no vote on this very unfair bill.
Lisa Smiley from Sacramento, please oppose this bill.
Ruth Ann Cawley, 40 Days for Life, San Rafael, and I strongly oppose this bill.
Mary Potler, Tiburon, California. I'm adopted. I strongly oppose this bill.
Ingrid Gallagher from Marin Network for Life. I strongly oppose this bill.
Dorinda Sears from Tiburon, California, member of Marin Network for Life, and I strongly oppose this very coercive bill.
Sue Ann Garbarino from Yuba County, small business owners, strongly oppose this bill. I've seen many women helped by our crisis pregnancy center. Thank you.
Walter Rilling, a citizen of the United States, and I strongly oppose this bill.
Dwayne Russell from Yuba City, California. As a strong supporter of the Women's Center in Yuba and Sutter counties, I strongly oppose this bill.
Judy Delgado from Placer County. I strongly oppose this bill on the grounds of constitutional rights and for the lives and savings of children, unborn or unborn.
I'm Bridget Potter from Nevada County, and I strongly urge you to please vote no.
Sarah Wynn from Nevada County, pro-life supporter, and I urge you, please vote no.
David Leatherby, local businessman, father of 10, great-grandfather to 31, grandfather to 30. Please vote no.
Bob Slakey, a private citizen. I urge you to vote no.
Good morning. James Anderson, pastor in Yuba City, California, and I urgently urge you to vote no.
Janelle Trevathan, member of the Board of Directors of a Women's Friend Pregnancy Clinic in Marysville and a 25-year client advocate at a Women's Friend, and I urge you to vote no on behalf of our over 5,000 supporters.
Democrats, for once, just say no to your Planned Parenthood racist masters.
Anyone else in opposition? Anyone else in opposition? All right, seeing none, I'll bring it back to the committee. Comments, questions from committee members? Mr. Gallagher?
Yeah, a few questions. The first question is, this is a Judiciary Committee, so we're very concerned about the law. And Mr. Chiu, I know you yourself are a Harvard-educated lawyer, so you can guess that there are some constitutional issues with this legislation. And probably most on point would be the Evergreen case that was before the Second Circuit, where New York City had a similar type of requirement that these clinics have to post this information or have to provide certain information, and they found that the court ultimately found that that was not narrowly tailored enough, that the government has the authority. They could do a citywide campaign letting people know about low-cost government programs that provide prenatal care and other health care for women. So, I think that case is pretty on point. They found that's unconstitutional. And in this particular case, we're talking about a very small minority of clinics out there that are completely privately funded. All the other clinics have government funding, and so we're saying to that minority that's completely privately funded, you need to tell about the majority of clinics who receive government funding and have a whole lot more advantages in terms of their funding than the privates do. Don't you see that there's going to be a pretty substantial First Amendment problem here?
So first of all, let me start by, I want to just take a moment and thank all the members of the public who have come out. There are certainly many heartfelt perspectives on both sides of this issue, and I very much respect the various perspectives that we have, and certainly my guest, Mr. Gallagher, and I, we may respectfully disagree on this, particularly as we look at the constitutional issues, but just want to appreciate the conversation here. As I said in my opening comments, we certainly drafted this ordinance very narrowly. Understanding and anticipating that there may be some who would challenge us on constitutional grounds. It is our perspective that this ordinance really is professional speech or commercial speech that would be governed by an intermediate constitutional scrutiny standard. And given the substantial government interest in ensuring that pregnant women are fully notified about their spectrum of healthcare options, we believe that it would be upheld in the courts. But that being said, Mr. Gallagher, since you are an attorney, if and even if a court were to find that this is a law governed under a strict scrutiny standard, we believe there's a compelling government interest in ensuring that pregnant women are fully notified about their spectrum of healthcare options. This is a narrowly tailored bill, given the time-sensitive nature of how pregnancy affects decisions and options, and we have not really been able to discern an alternative that would achieve this compelling interest. And let me just also suggests that in the Evergreen case, the Second Circuit in New York actually did uphold language very similar to what we're talking about here. And if I may quote, the Evergreen Court in New York said that the government has a compelling interest to ensure that women have prompt access to the type of care they seek, and to prevent women from mistakenly concluding that pregnancy service centers, which look like medical facilities, are medical facilities, whether or not those centers engage in deception. And let me mention one other thing, which is NARAL, as you probably know, had a study where they found that 91% of the clinics that they sent individuals into found that those clinics were providing information that suggested that abortions led to breast cancer, infertility, mental illness. We heard from Mr. Hadley, representing the opposition. He suggested that oftentimes in these clinics there may be things said that shouldn't be said, and that's part of the challenge of what we're trying to do here. We have narrowly tailored this to require licensed facilities to provide a simple notice that there are a range of options, but we're not dictating what those options are. It is viewpoint neutral.
I have a few other questions, Mr. Chairman.
Go ahead.
Well, again, in the Evergreen case, there was actually three parts of that the city of New York did. First of all, they said that the clinic would have to say whether or not they had a licensed medical provider on staff. That was one. The second one is they wanted them to state the fact that the New York City Department of Health and Mental Hygiene encouraged potentially pregnant women to consult with a licensed provider. And the third portion,
which we do not do here, right? That's not
and the
part of
third
this.
portion was whether they provided referrals for abortion, emergency contraception, or prenatal care. The court upheld the first one only, which is a statement that the person, whether or not they have a licensed physician on, which is not before us at all today. But
actually, it very much is in front of us today. In fact, that is half of what our
not
ordinance
on
is
this
about.
provision that we're all talking about, because your notice does not say anything about a licensed provider. The notice says.
Actually, Mr. Gallagher,
the notice
a
says
significant portion of our bill refers to unlicensed clinics.
I understand that, but I'm saying the part that everyone is opposed to and that everybody's talking about is this notice where you're saying California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women. There's nothing in that statement that talks about a licensed physician. So that's what we're talking about. That's the speech issue. And in the New York case, it was the latter two provisions that were struck down by the court as unconstitutional, because they provided them to tell clients who came into the facility that New York City Department of Health and Mental Hygiene encouraged pregnant women to consult with a licensed provider. That was struck down.
And we don't have that provision in this bill.
And whether or not, and asked them to tell them whether or not they provided referrals for abortion, emergency contraception, or prenatal care. So I think that's very much on point here, because what you're saying is that they have to provide a notice that, hey, there's other facilities out there, government facilities that provide abortion. That's going to be the specific issue that was basically struck down by the Second Circuit. So there's already a case law, federal case law on point that says you can't do this. I think that's a problem for us as the Judiciary Committee to go ahead and approve legislation that's going to be unconstitutional as soon as it was passed.
And to be clear, Mr. Gallagher, and I think what Mr. Chiu is getting at, because of those cases that are out there, the analysis, which I understand is long and fairly detailed, but it distinguishes between not the license of the physician, but a licensed facility versus an unlicensed facility. And the analysis addresses the constitutionality differently in each case because of the cases that were brought.
So that's where I was going to go next, because I believe you, and we've talked about this, when you say, look, this is about just providing the full range of options that women have the full information and spectrum of care that is out there and available. So if that is the truth, would you take as a friendly amendment something that would require all primary care clinics to provide the full spectrum of information and care that's available to them, including the counseling and prenatal care information that they can get from these crisis pregnancy resource clinics, information on adoption for those that maybe want to choose that as an option? Should we provide these same clinics who are before us today saying that we should support this bill to do the same thing and use their speech to talk about a woman's friend in Yuba City or any of these other clinics that provide resources to women as well?
So what I would say to that is the providers that we're talking about, many of them actually do offer the full spectrum of healthcare services. In fact, the types of clinics that I think you would suggest ought to provide conversations around prenatal care and caring, caring to full term, that is already provided by the clinics that we're talking about. So I actually don't think that would be necessary. But what I do want to be clear is there's nothing in this bill that requires any referrals to abortion clinics, that provides any sort of preferences of one kind of clinic over another. It's a simple notice that there are free or low-cost public programs reflecting really the range of care that is out there. Let me also just mention that the Fourth Circuit, as you probably know in the Centro Tapaya case, also upheld similar language to what we're talking about here, again reiterating a compelling interest, again reiterating that the notices that we're talking about were narrowly tailored, and similar language, again, held constitutional.
But again, if the objective is to provide the full range of services, because there are a lot of primary care clinics that don't provide the information that we just talked about. They're geared up to do certain things, but they don't provide information on adoption. They don't provide information on different prenatal care. They're just not geared up to do that. So should those facilities that don't offer those services be provided to give information about, hey, there are other clinics that are available in the community? If we're going to provide the full range of options, which I agree with you, then should we not be doing that? I would imagine that if you did do that, maybe you wouldn't have the support for your bill.
Again, I think I would disagree. I think I would disagree
Can
with
I ask
the
the
premise.
audience to please refrain from interrupting or disrupting?
I think I would disagree with the premise of what you're suggesting. The clinics that we're talking about do provide the full range. In fact, I'd be happy to defer to one of our witnesses today to talk about that.
Thank you. So what we're trying to achieve with this bill is actually a standard of care, so that women who are pregnant and seeking services for their pregnancy-related counseling, so if you break your leg and you go to a primary care person, you don't need information about pregnancy. What we're trying to do with this bill is make sure that the standard of care is met for every pregnant woman seeking information about contraception, prenatal care on having a baby, adoption, or abortion care. So this bill is only bringing everybody up to the same standard, because what we have found is that not every pregnancy counseling center offers that. This bill specifically says that if you're already enrolled in FPEC and Medi-Cal provider, you're already required by law to disclose this information. So this is bringing that level of care to everyone seeking care regarding or information regarding pregnancy.
So if that's true, why doesn't your notice say adoption in it? Free or low-cost access to comprehensive family planning services, prenatal care, adoption, counseling. I don't see any of those services listed in your notice.
Although I understand what you're saying about providing all the options, I don't believe that adoption is included as a medical service.
No, but it might be something that people who are trying to get information on different options that are available, how would I go about doing an adoption if I wanted to do that? Is there...
And if I'm allowed to answer, like was stated, that if you are able to take Medi-Cal reimbursements, that is part of the requirement of those clinics, which, as you said, is the reason that some of these notices to make an even level playing field, even in the private clinics, is necessary.
Is there a requirement under Medi-Cal that they provide information about the crisis resource clinics that are in their community?
No.
So that's what I'm saying, is you have an uneven playing field here. You're saying that these privates who receive no funding, no government funding whatsoever, they're completely private, have to tell about the government-funded programs that are out there. But the same is not true of the government programs. They don't have to say that, hey, there's these other groups out here who have qualified, licensed people providing the information. They don't have to tell about these privates. That's where I think we're going to have a huge constitutional issue.
I think part of the issue is that right now a California clinic that is licensed and receiving Medi-Cal cannot refer to a clinic that is not providing the full range of services.
Okay, but you want the privates to tell about that public, though. See, it's uneven.
It's a constitutional right for me to understand all of my rights, and so as a woman and as a mother, yes, I'm asking that when anyone enters a clinic, that they be provided with all the information, not necessarily all the services, but all the information.
I agree, and I think all these, hundreds of women who are here today would agree with you that you should be provided with all the information. There's also a constitutional free speech right at issue, and that's what I'm concerned about as a member of the Judiciary Committee.
And like we said, I think we all agree. We're just trying to create a standard of care that is an equal playing field for all of us. And how we get there, we'll work together to get there. But it should be a standard level of care for all.
All right, last question, I promise. If I were to bring a bill before this committee based on a report from a pro-life organization that had done investigations in some of the public clinics around the state. Let's say it's focused on the family, James Dobson's organization, that did an investigation and found out there was misinformation being given in these public clinics, that they weren't doing things correctly. And then I had the same bill on the flip side saying, hey, they have to tell about that these public clinics have to tell about the private clinics, and that that they offer services to women as well. Would you support that bill? Because that's what you're asking me to do, right?
So, if there was such a report, I certainly would take a look at it. I would be happy. I would be happy to have a conversation with you about it. And if it turned out that the facts in that report were true, I would be troubled, and I would be happy to work with you on how we would address factual inaccuracies. But on the flip side of that, what we do know is that, again, 91% of the clinics that we're talking about, women who walk into these clinics are told that there are direct links between abortion and breast cancer, between abortion and infertility, between abortion and suicide, between abortion and mental illness. And really, what we are doing with this law, it's a very narrowly tailored policy to address the compelling government interest of ensuring that all pregnant women are notified about their full spectrum of health care options without referring to specific abortion clinics, without suggesting that one clinic is better than another.
But you can see why I'm a little bit dubious of that report, right? Because this is from NARAL, their whole focus is on abortion rights, correct? So it's their report. If I came to you with the same report that said 91% of public clinics are doing something wrong, and it came from Focus on the Family, let's be honest, man. Would you be dubious of that report? Would you accept that as completely true? Or would you say, hey, there's a bias here, there's an inherent bias because both of these groups are ideologically focused on an issue?
I would be happy to, again, take that report as seriously as I do any other. I looked at the fact base and talk with you about how we address it. But I like to defer to Assemblywoman Burke.
Well, and for the sake of argument, that is a hypothetical. That is not a bill that is before us. And if any member did present that bill, it would get the full analysis that this bill got as well. So I want to caution everybody from going too far down a hypothetical train.
Not a hypothetical. Thank you, Mr. Chair. Mine is not a hypothetical. So I have actually had the experience. I was not even going to a clinic for an abortion, and I was given a tremendous amount of misinformation. So for me, the reason I'm a part of this bill is because it's my personal experience. It's not from the report. So I just want to make that very clear, that I have personally received information that I found not factual or that was not factual. So I just want to make sure that that is clear.
Okay.
All right.
I do have a comment later, but I'll
make a comment. Go ahead.
Well, are we waiting until everybody has questions? Or?
Well, I have Mr. Wagner, but I don't have anybody else yet. All right, Mr. Wagner.
Thank you. Mr. Gallagher stole most of my thunder, at least on the legal side of things, and I appreciate that line of questioning. I guess I would, to be honest, we all know what this bill is about. It's about abortion, and the word abortion that appears 4 times in this bill. I don't think it's narrowly drafted. I do think there's a very easy alternative that would satisfy the 100 or so people who testified in opposition to this bill and the thousands and maybe tens of thousands of our fellow citizens that they were representing, and that, frankly, we're here to represent as well. And that would be to strike the word abortion where it appears in this bill. Then it probably sails out of here. All of these people thank you, and they go back about their daily lives. I guess I'll just ask, would you be willing to take that friendly amendment?
As you know, under Roe v. Wade, a woman's right to choose is the constitutional right of all women in our country. And again, our bill is very narrow. It simply says that licensed facilities provide a simple notice of the range of care, prenatal care, family planning services, as well as abortion services. And it also says that unlicensed facilities, if they are unlicensed facilities, need to disclose that there are not that they are unlicensed and they don't have licensed medical providers on staff. Again, I think it's very narrowly tailored. I appreciate, again, the difference that we have colleagues on this issue of choice, and I would just respectfully suggest that we may have a difference that may be difficult for us to resolve in this bill.
That's a no to that friendly amendment.
That would be a no.
All right, thanks. All right, so let me talk for just a minute about the, I'll use your phrase, the heartfelt perspectives that we heard from the opposition. Thank you for recognizing that indeed those were heartfelt, because I think they were. What I fail to see in this bill, unfortunately, is an appreciation of those heartfelt perspectives. This bill is bringing to the legislature and asking us to use the very heavy hand of government to force private citizens, our constituents, to violate their conscience, to speak on behalf of the government and offer to somebody something that in some cases, well, in all cases, violates their conscience, in their opinion. Whether they're right or wrong, whether it would violate your conscience or mine doesn't matter. It violates theirs. Some of the Catholic folks that were here testifying believe heartfelt, maybe wrong, maybe not your theology, maybe not mine, that something like this forces them to close their doors or quite possibly violate their religion, consign them to hell if you want to go that far. How can we, in good conscience as a government, force that on our citizens when in 2015, the idea that a pregnant woman in the state of California would be unaware that abortion's out there and perhaps an option, just boggles the mind. How can we, as a government, force our citizens to violate their conscience? And isn't that exactly what the First Amendment says we can't do, shouldn't do, and frankly aren't true to our oath of office if we try to do?
Again, the suggestion that there's anything in this bill that would prevent a center from providing the services that they're currently providing is just not true. There's nothing in this bill that forces any of these clinics to close their doors, that requires clinics to not engage in whatever they're engaged in at this point. And again, it's a simple notice requirement that's 2-3 lines long. That simply says that there are free or low-cost public programs for a pregnant woman to avail herself of the spectrum of choices that she faces.
It doesn't matter how long or short the notice is. It doesn't matter how simple it is. It doesn't matter that it talks about something that the Supreme Court has told us is a constitutional right. It violates the conscience of citizens who have given you their heartfelt perspective, to use your phrase. Simple or not, use small words, use big words, that's not the point. The point is they are telling people in violation of their conscience that there is this procedure available that they, rightly or wrongly, believe results in the death of an innocent human being. How can we, whether we write a simple notice, don't tell me it's a simple notice, don't tell me it's 2 lines long, I can read it. How can we in good conscience foist that on our constituents who believe, like they do, that abortion is wrong?
Again, I think this is just an issue that we will respectfully disagree on, although I do want to mention we do know that there are many women in our state who, when they're pregnant, may not know exactly what their options are. Certainly within immigrant communities, certainly within low-income communities. And when they see the ad, pregnant, scared, and they walk into a center, and again, they're told that an abortion will lead to all sorts of horrific things, it creates a number of challenges for government as we think about how to protect a woman's constitutional right to choose. So, again, respectfully disagree. We may not be able to agree on this one, but we have certainly done our best to narrowly tailor this to address a substantial government interest.
All right. Last question. Why is abortion so important to you people that you will require a violation of conscience? You won't put in adoption when you say, well, we want the whole range, but you won't put in some of those, that you stand up here and tell us something that is patently not true, that there are people out there in California in 2015 that don't know abortion is available. What is it about that procedure that's so important to you?
First of all, we're not you people, so I'd like to first address that.
I'll be clear, Democrats.
Okay. That's fine. That's fine, but you people is not appropriate, I don't believe, for this forum. And the second thing is, because it's my constitutional right. As a woman, I've earned that right. It's the law. So all I'm asking is that people be provided the information that is their right to have. That's it. I'm not asking anyone in this room to do it. I'm not asking anyone here to partake in it. And by the way, Mr. Hadley, I'm sure Mr. Hadley's clinic provides all the information that they would like to provide, and they do excellent service. However, if a young woman who is scared walks into a clinic and doesn't know her options, she should be provided with all of her options. He doesn't have to do them. He doesn't have to be referred out. But I think that there should be a standard of care for all women, low income, everything.
No.
All right, since we won't be getting a chance to come back for comments, I mean, you make the bill sound like, baseball and motherhood and apple pie. Well, maybe not motherhood, but baseball and apple pie, and all we're trying to do is provide notice, but the unwillingness to take either of the proposed amendments and the single-minded focus on something that violates the conscience of a significant percentage of our population, frankly, gives away the game. We know what this is about. It is unfortunate. It is unfair. It is a misuse of government, and I do believe our oath requires us to respect the First Amendment rights of the men and women that were here testifying and the folks they represent. And for that reason, I will be a no on this bill.
And I would respond that I would say that our constitutional oath requires us to protect both a constitutional right to choose as well as constitutional First Amendment, and I believe this ordinance does both of that.
Mr. Gallagher?
Yeah, I just wanted to summarize, my feelings and just talk to my fellow committee members about this bill. First of all, we're the Judiciary Committee. We have to be very concerned about constitutional issues. And I think this is very clearly, there's already federal law, case law on point that we can't do this. We can't force a small minority to put this out there when it's against their conscience, when it's against their beliefs. And when the government is requiring a completely private group to do it, when the government has so much more power, as it was said in that Evergreen case, the government, if it really wanted to make sure that everybody had the full range of information, the government has the money to embark on an advertising campaign. That's exactly what the court said. That is a more narrowly tailored way of doing it, where you could let all people know and embark on a much more public education campaign to ensure that women have the full range of options and information in making decisions. You can't require a completely private group who doesn't have the benefit of public funding. They get no public funding whatsoever. So they're already at a huge disadvantage in that respect. They make up the vast minority. We're talking about, I think it's 4% of the clinics in the entire state that we're putting this mandate on. All the other clinics don't have to do it. They're specifically exempted in the bill. So we're saying to 4% of the clinics, hey, you have to provide this information. It's clearly unconstitutional, and we shouldn't allow bills to pass out of this committee that we know aren't going to pass constitutional muster. I think the second thing is that I take pretty great umbrage with this NARAL report. I think it's clearly biased. They're going in for one reason and one reason only, to find something wrong. And I think if you go into any place and you're looking to try and find violations, you're going to find problems and you're going to go report them, right? And I know that if this was like Focus on the Family that came out with this report about, say, Planned Parenthood or some other public clinic, there's no way you would take that as, oh yeah, that's an objective information that should be the basis for legislation. So I think using that as the basis for this legislation, I would need something a whole lot more objective and third party that's not vested in this in this ideological fight in order for me to make that as the basis for legislation. But furthermore, all these people in here that came here today, the vast majority of which are women, strong, independent, caring, passionate women, who many of them were in the same exact case, in a crisis pregnancy, not knowing what to do, and went to the public clinics and feel like they didn't get the full range of information themselves. And that's exactly why these groups were formed in the first place, is because they're trying to provide alternatives. They're trying to provide that full spectrum that you're talking about. That's why all this private money has gone into it, that people believe in that. And to think that these women who came out here and testified today, and I know them because I talk to them a lot, actually, and I know where their heart is, and it's exactly where yours is, Assemblymember Burke, is that they want to make sure that women have information and the full spectrum. They spend hours counseling and talking women through this decision because they care. And so for NARAL to try and put the black mark on them and say, you guys are providing misinformation to people, not a one of these women would do that. Because, again, they were in the same position themselves. And to try and, make them look bad by this report, I think is completely, I take great umbrage with that. And the biggest thing that these places provide is they provide hope. I've been involved with my own local crisis pregnancy resource center. I support it. I hear the testimonials from women who went in there and they were helped. And I just heard one actually last week, a woman who went in, she was addicted to heroin, pregnant. What am I going to do? And talked with her counselor, with her advocate. And today, she did end up having the baby, but she's off heroin. And that's because her advocate helped her get into drug treatment, helped her get all the things that she could have so that she could provide a good life for her child. What is wrong with that? These people are providing a huge resource for us, and now we're going to kind of paint them in a bad light. I just don't think it's fair, and I agree. It's all about perspective. Like, you had your personal experience. There is also, and I just want to read this. This is on Yelp. Crazy that Yelp these days, you can get all kinds of testimonials. This is one from a woman who visited the SAC Life Center, and you guys all have it in your packet there. And it says, the SAC Life Center perhaps has pro-life leanings, but there are no priests with rosary beads or holy water or right-wing anti-abortion fanatics with baby killer signs lingering in the vicinity of the office, which I must add is very centrally located and quite convenient to park at. Believe me, by no means will you be made to feel pressured or guilted into a choice involving your body or bringing a life into the world at the SAC Life Center. Rather, you will receive an overabundance of information to help you make what may be the most difficult decision of your life. The NICE staff will help you with insurance or aid from the state if you need it. They will fill out all the paperwork for you. They will find a doctor for you. They won't give you information on abortion clinics, but easy enough to find that on Google. Women's Health Specialists, Planned Parenthood, etc. They even provide options for baby daddies to get information and advice. You will feel cared for. If you have a husband or partner or just want to be a mother, they will celebrate with you. If you are alone and scared, you won't be anymore. I'm not a religious person, but I can truly say that finding the SAC Life Center was a small miracle. And I think that this is important. So why are we attacking these groups? We should be supporting them. And that's why I'm urging this committee to either oppose this or let's make this, if we're trying to give notice to everybody, let's make it an even playing field and everybody has to provide notice of the services that are available, including this great asset of clinics around the state that provide women with an awesome environment, a caring environment, counseling, and help. Let's not make them the bad guy. Let's make everybody, let's show women that there's all kinds of services available to them.
Thank you, Mr. Gallagher. Ms. Garcia.
Thank you. So I've had the I've visited some of these centers near my district that service, and I want to say that a woman should have a choice about what we do with our bodies, and a choice about which facilities we go into and who we're going to be patronizing with. And so having these alternative centers is appropriate for some women, and I don't feel that this bill is taking that choice away. This bill is not taking the ability from these individuals, including those that are in my district, to continue to do that counseling, to continue to say, is adoption your path, or can I help you be a sponsor to help you get clean so that you can care for your child? Those choices should exist, and I don't feel that having this disclaimer limits or stops those institutions, those groups from having those discussions on a regular basis with individuals. I've talked to some of the providers at the centers, and they talk to me about how they have women coming in who have had abortions and maybe for the second child have decided they don't want to go that path. And they're discussing what that means, and they're providing counseling for that. And it's trying to make sure that they're not passing judgment. If part of having that choice, it means supportive of not passing judgment for decisions that we make along the way. I think telling them these are your options, yeah, they're talking about, and they're using the word abortion, but it's a word that's being discussed in these centers already, because mothers are coming in wanting to talk about it. And as a good counselor, you're not going to say we can't talk about that, right? And so I don't feel that this bill limits any of these groups from having those conversations, from advocating for their rights. It's just saying these are all the different things out there, and while this center might not provide it for you, if you want to explore that option, here's the number, you could go look into it otherwise. And it gives you that full spectrum of choice here with some very simple information, and maybe not simple at the conscious level that you want to talk about and issues that we need to deal with. I don't want to dismiss that in any capacity, but it is about choice, not just of what I do in my body, but you're still able to walk into those centers. And there are good centers that do talk about out there. And I haven't read the whole NARAL report, but if I'm just going to go from personal experience, I've seen both sides, where I've also seen the misinformation when I've walked into centers myself. And I've seen the other side, because I have to say I've been invited by some of these providers in my district to say we're not all the same. It's a spectrum here. And so I think this bill allows you to continue to be the provider that you want to be while sharing some information out there. As a woman, I want to know that I have multiple options and make that decision for myself along the way of what I do. And I don't think that the statement reads in such a way that you are advocating or saying this is a better choice than something else. I think it's just saying that this is out there, and it is something that we know we have. But sometimes when you are in crisis mode, even things that seem like, duh, you should know this, it's out there, it's like you're blinded. It's hard. You're dealing with so much emotional stuff in that moment that saying, hey, this is a choice and we're not going to pass judgment on you, is important for us to hear sometimes. And so I am going to be supporting today's bill. I think as we have this discussion, we should, though, be sensitive to these providers, because there are good ones out there, and we can't be painting them all with the same paintbrush.
Thank you. I'm still looking for a motion. The recommended action is do pass to appropriations. We do have a motion and a second.
I'll move to amend the bill to provide disclosure, to provide that public care facilities have to provide the same disclosure about the crisis resource clinics that are available in their community.
Is the author willing to take that as an amendment?
As I said before, the vast majority of these centers provide the full spectrum of healthcare options that we're talking about here. So the answer is no.
Mr. Chiu?
No.
Answer my question.
No.
Are you willing to take those as an amendment?
Not.
Okay, I will take a motion to lay the amendments on the table. So Ms. Garcia is moving to lay the amendments on the table and is asking for an aye vote. Mr. Gallagher, I'm assuming, is asking for a nay vote. This is a vote of those present.
Has there been a second of the motion?
There is a second on the motion. This motion is not debatable. Would you please call the roll?
Stone?
And the motion is to lay on the table, so my recommendation is an aye. Aye.
Stone, aye. Wagner?
No.
Wagner, no. Alejo? Chow? Aye. Chow, aye. Chiu?
Aye.
Chiu, aye. Gallagher?
No.
Gallagher, no. Garcia? Aye. Garcia, aye. Holden? Mainshine? O'Donnell? Aye. O'Donnell, aye.
5-2, that motion passes. Those amendments are laid on the table. So we do have a motion and a second. Mr. Chiu, I want to thank you for bringing the bill here. There is a lot of emotion, controversy that have been brought up. You've heard that in the testimony. You've heard that in comments from the dais. The questions about constitutionality, I think, were very well answered in an excellent analysis that went through. We took that very, very seriously in this committee and looked closely at what decisions were out there and how they could affect this. And in fact, I do know that that is why there's a difference between the statement for a licensed and an unlicensed facility. That is appropriate. Of course, anything and everything we do in the legislature is subject to judicial challenge, but I have great confidence in the analysis and the appropriateness of the analysis, and I feel that, Mr. Chiu, you've solved the constitutional questions. So with that, I'm going to ask you to close. Ms. Burke, you may also be a part of the close as you're a joint author if you wish.
I'll give my time to Assembly.
Again, I just want to thank colleagues your deep consideration of these issues, and again, also want to thank the committee staff for your deep analysis of this as well. Colleagues, as I've said, this is a narrowly tailored policy to address a very compelling government interest, and I respectfully ask for your aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
No.
Wagner, no. Alejo? Chow?
Aye.
Chow, aye. Chiu?
Aye.
Chiu, aye. Gallagher?
No.
Gallagher, no. Garcia?
Aye.
Garcia, aye. Holden? Mainshine? O'Donnell?
Aye.
O'Donnell, aye.
The bill is on call. You need one more vote. All right, thank you. We are now going to move to item 16, AB 1407. Madam Speaker.